but I just haven't heard of it happening in California, and I'm wondering if anyone knows of any examples. Have there been any major cases of that kind? I'm thinking back to the major litigations where other states used outside counsel, like lawsuits against Microsoft, for example. Many states piled on to the Justice Department's antitrust case against Microsoft, hired outside counsel on a contingent fee basis to bring suits in state court based on state antitrust statutes. It was my understanding that then, when that happened, California's AG used AG staff attorneys. And in most other cases that I can think of, the California's AG's office just uses staff attorneys. So I'm just curious as to whether this is really a phenomenon of concern in California or only in other states.
John?
I think there was an example of outside counsel being retained on a contingency fee basis to pursue groundwater contamination fees, at least as reported by the Wall Street Journal in an article about a year ago. Beyond that, I don't know.
Okay. Any other comments?
Well, the AP found that there were, the suits brought against the utility companies, that there were 11 firms that received $1 million in attorney fees from a $1.6 billion settlement from the utility companies.
What litigation are you referring to?
Well, this is one that was marked confidential, and it was just brought against the utility. I don't know the specifics of that.
Are there any downside in posting information about the contracts?
None that I can see. I think there's nothing. I can't imagine anything being in a contract with an outside law firm that the public doesn't have a right to see, and that we wouldn't want the public to see.
We're all in agreement on that. Okay. What about the concept of contingency fee? You know, in the state of California, you cannot pay an expert based upon a contingency. Here you have the government going out and hiring lawyers on a contingency. Is there anything that's inherently that you would question on that?
Absolutely. In another article, there's a reference to a California Supreme Court case. I don't have the citation. We could probably track it down. Where the California Supreme Court ruled contingency fee representation as improper as, quote, antithetical to the standard of neutrality that an attorney representing the government must meet when prosecuting a public nuisance abatement action. Again, I think the attorneys that are hired are stepping into the shoes of government, and we hold government to a higher standard and don't want these certain kinds of behaviors you want to incentivize. But is this the kind of behavior you want to incentivize? Absolutely not. It would result in overzealous prosecution. It would be like, pegging a deputy DA's bonuses on his conviction record. I mean, really puts in an incentive to get convictions as opposed to do justice.
Any other views? Bob?
I think, as Lorie alluded to earlier, the public interest may be best served by some kind of injunctive relief as opposed to money damages. An outside private counsel working on a contingency fee is merely going to be interested in a cash settlement and getting their cut of that. So clearly the public's interest may not be served by these contingency fee arrangements. And also, as we've seen in the past, particularly in the tobacco litigation, the hourly rates, if you do an effective hourly rate calculation at the end of the day, that some of these plaintiffs' firms have received in excess of $1,000 an hour, which is clearly exorbitant, and I think should be somewhat subject to some negotiation after the fact by the state.
Any other thoughts on contingency fee? Who is the client? When the Attorney General files a civil suit, the Attorney General decides to file the suit. The Attorney General decides how to prosecute, who to hire if you have outside counsel, I guess who the experts are, how much they're paid, and then decides whether to settle it. Is that how it works? Or do we actually have a client in the mix? Anybody like to?
The client is the people of the state of California.
So do we take a referendum on whether to file and whether to settle the case?
No, that's just I would say that's the constitutional scope of the authority to represent the people of the state of California, either as in criminal prosecutions or civil prosecutions. And therein lies the rub. Do you want to, there are other functions, for example, we don't contract out. We can contract out road building. Road building makes a lot of sense to contract that out because a lot of people in the private sector do that. But do we contract out police services? We sometimes contract out fire protection services, but police services, the nature of that is where people are out there representing the government, enforcing the law in a confrontational environment. Is that something you contract out to people who bid on it? I don't think so.
Well, the argument on the other side is that sometimes a state is going to be involved in litigation. The issues are extremely complex, factually and legally. You're up against a large corporate law firm on the other side as your adversary, and an attorney general sort of thinking about litigation strategy and being honest with himself is going to say, you know, we're not going to be able to win this if we don't have outside help, or if we do win it, it's going to be at the expense of everything else that we do because it's going to exhaust all of our resources, and it's going to require some real expertise in particular areas of litigation. And so we'll reach out and hire outside counsel, and then entering into a contingent fee arrangement, well, from one standpoint, all that does is save the state money. The state only, the lawyers are only paid if they win, and if they win, they're paid out of the settlement or the damages that are awarded in the case. So from the state's, from a purely fiscal standpoint, and from the state's perspective, it's just it can be just a win-win situation. So one can imagine situations, circumstances where it would be appropriate, I think, to hire outside counsel. I think the important thing, though, is that it should be the exception, not the rule, and it should be done in the full glare of public understanding of what the terms are. And it shouldn't, the outside firm hired should not be one that has made campaign contributions to the Attorney General, because that's a blatant conflict of interest. There are lots of ways to regulate it, but I don't think one necessarily would want to go so far as to prohibit it. Even the federal government, I keep coming back to this case because I know something about it, even the federal government in its landmark antitrust case against Microsoft, with all of its expertise in-house, including some of the best antitrust lawyers in the world, when it sued Microsoft, it hired David Boies to actually be the trial lawyer with his team of lawyers from his law firm. They didn't do it on a contingent fee basis, of course. It was done differently. He actually became a temporary employee of the Justice Department, technically. But even the Justice Department had to reach out to outside counsel, and does so from time to time. And there are appropriate times, I think, for state AGs to do the same thing.
So, do all of our council panel members agree that we should ban contributions from potential outside counsel? That is, otherwise, if you've contributed to the Attorney General's campaign, you are not eligible to become an outside counsel?
Yeah, I think with some temporal, if you gave 2 years ago and clearly whatever contribution has nothing to do with what is going on today, but if it, within close proximity in time, absolutely it should be a prohibition.
Everybody?
Well, I'm not a lawyer, but just thinking about it as a taxpayer, I don't know about a prohibition, but in the last, like you said, year or two, but if it's up for competitive bidding and it's in the the light of day, I don't know that that's necessarily going to be a huge problem. It's a problem the way that it is now, but I don't see that that's a huge problem. I think the campaign contribution should be up there too, for the light of day, all in context. Like I said, just a taxpayer's thought.